Good morning guys, my name is Shiven. I am a second year law student from WIPS IP Delhi. So today I'll be talking about the topic restitution of conjugal rights. So restitution of conjugal rights is basically defined in section 9 of Hindu Marriage Act. It states that marriage under all matrimonial laws imposing certain marital duties and gives to each of them certain legal rights. The necessary implication of this marriage is that the parties will live together with each other. Each of the spouses is entitled to comfort the other. After solemnization of marriage, both husband and wife are legally bound by the law to maintain their conjugal life together. If either of the spouses departs from the other, then the aggrieved spouse may acquire statutory matrimonial relief guaranteed under the codified personal law to restore their status of the subject to validation of certain facts. This can be done by filing a petition in court seeking for resumption of cohabitation. This right is known as restitution of conjugal rights. So, meaning of restitution of conjugal rights. Restitution of conjugal rights basically comprises of two major words, restitution and conjugal rights. Restitution means restoration of something lost. Conjugal right means rights relating to the marriage or relationship between the husband and the wife. If either party to a marriage withdraws from the society of the other without any reasonable cause, the aggrieved party has a right to file a petition claiming relief for restitution of conjugal rights. The court will grant the relief if there is no legal bar to such decree. So what are the conditions to be satisfied to obtain this decree? The conditions are, as I am saying, the other spouse has the other spouse must have withdrawn from the society of the petitioner. There is no reasonable excuse for such withdrawal. Should the respondent allege reasonable excuse, the burden of proof lies on him or her. The court satisfied as to the truth of the statements made in the petition. No legal grounds exist for refusing the decree. There is withdrawal from the society when one of the spouses without any reasonable cause. So there was a case, Ranjana Kejriwal versus Vinod Kumar Kejriwal. Petitioner was the wife, and alleged that the husband was already married and had suppressed the fact from her. The court had held that the petition for restitution of conjugal rights is non-maintainable since the marriage is not legal. So thirdly, I'll be talking about the burden of proof, like who has to prove. Restitution of conjugal rights can be claimed when the party to the other marriage has withdrawn from the conjugal society without any reasonable care. It is for the party who has withdrawn from conjugal society to show valid excuse. This excuse should be reasonable and convincing. The facts that the aged parents of the husband are residing with him, or that the wife has to look after her deceased father's land, are not reasonable excuses. These are vague excuses. However, a wife would be justified in leaving her husband if she is forced to have non-vegetarian and any other thing which against her will, like drinking alcohol, marital rape and whatnot, etc. Application of the provision in different communities. Section 9 of the Hindu Marriage Act provides for the restitution of conjugal rights. The aggrieved party may apply by the petition to the district court for the restitution of conjugal rights. One of the main important implications of Section 9 of the Hindu Marriage Act 1955 it provides an opportunity to the aggrieved party to apply for maintenance under Section 25 of the Hindu Marriage Act. The legal grounds for refusing the grant relief, for instance, any ground on which the respondent could have asked for a decree for judicial separation or for nullity of marriage or for divorce. In Muslims, if the husband either deserts a wife or neglects to perform his marital obligations without any proper reason, then the wife can apply for restitution of conjugal rights. Even husband can apply for restitution of conjugal rights, but the courts can refuse to grant order to restitution of conjugal rights for following reasons: cruelty by husband or his in-laws, on the failure of husband to perform marital obligations, non-payment of prompt dower by the husband. In Christians, a Christian husband and wife can also apply for an order of restitution of conjugal rights. The court cannot pass the decree for following reasons: cruelty of the husband or wife, if either of the spouse is insane, if any of the spouse marries again. So basically, the constitutional validity of conjugal rights was challenged in the case of which was presented before the court of Andhra Pradesh, that was T. Sarita versus Venkat Subbiah. In this case, Sarita claimed that Section 9 of the Act is liable to be struck down as violative of the fundamental rights in Part 3 of the Constitution of India, specifically Article 14 and 21, which talks about the rights. Justice Chaudhary held that Section 9 is a savage and barbarous remedy, violating the right to privacy and human dignity guaranteed by the Article 21 of the Constitution. It denies the woman her free choice whether, when, and how her body is to become the vehicle for prosecution of another human being. The woman loses her control over her most intimate decisions. Clearly, therefore, the right to privacy guaranteed by Article 21 is flagrantly violated by a decree of restriction of conjugal rights. As a result, the Section 9 of Hindu Marriage Act 1955 was unconstitutional. Furtherly, ultimately the Supreme Court in Saroj Rani vs. Sudarshan gave a judgment and views and upheld the constitutional validity of the Section 9 of the Hindu Marriage Act 1955 and overruled the decision given in T. Sarita vs. Venkat Subbiah. This was it. This was Restitution of Conjugal Rights before you. Thank you guys.